For those of you who missed it, my name is Paula Price. I'm with the People's Law School. I am helping them develop their webinar programs, and this is our program debut, and we are so excited to bring this topic to you today. It's very timely, your rights as a worker in the time of the coronavirus. And we wanted to do this webinar to respond to what we perceive to be a very urgent public need. So we want to welcome you all here today. We're going to start out by running a poll to see, to learn a little bit more about who you are with us. So if you will keep an eye on your screen, you should see some questions. So what best describes you? Are you a worker, a legal professional, someone other than a legal professional who helps people with legal problems, or none of the above, but interested in the topic? So if you'd like to complete the questions and submit your answers, we will share that with you. And for those of you who are watching, oh, okay, and here we've got our results. So we have most of you on the line today are workers. Excellent. We've got legal professionals. We've got non-legal professionals who are helping others, and some of you who are here for interest. So welcome. It is so great to have you here today. We know this is a really difficult time for a lot of people, and there's a lot of uncertainty right now. And so we really appreciate you taking the time out of your schedules to be here with us today. So this webinar is for workers. We distinguish between workers and employers. Employers are also facing their own challenges in these times, but we're really focusing on individuals who are workers. So by that, we are referring to workers who are not in a union, who are regulated by the province, and who are covered by BC employment standards. The information that we're sharing with you today is applicable in British Columbia. If you're attending from out of province, you are more than welcome. We are glad to have you with us. Just please note that the rules may be different in your province from how they are in BC. And we'll be covering questions about the impact of the coronavirus on your legal rights as a worker. We'll be answering over the next 45 minutes some of the most common questions that we've been receiving. So at People's Law School, and Sarah and her team over at Forte Law have been receiving a number of questions from workers in British Columbia, and we've gathered the ones that are the most common. We will be providing you with legal information and not legal advice, and the difference there is legal information is more a statement of the law as it is currently. Legal advice is more the law as it applies to your particular set of circumstances. The information that we're providing is current as of today, April 3rd, 2020, and this particular area of law has been quite a number of changes recently as the government adapts to the coronavirus pandemic. And so we just want to make sure that if you're watching this, a replay of this webinar, that you make sure that the information is up to date. We've talked a little bit about the functions that are available to you as a viewer. So if you have questions and comments, you can look to your toolbar and submit those. We are going to see if we have time to answer questions today. We have a pretty full program for you, but if we have time at the end, then we'd love to answer questions for you. If what you're seeking is legal advice, then we would ask that you please direct those inquiries to Forte Law, and their email address is here. It'll appear on a later slide as well. And I know you're all getting really excited to hear our speakers, so just a few acknowledgements before we get there. First, we'd like to acknowledge, I'm speaking on behalf of Peoples out of Vancouver, BC. And I'd just like to acknowledge that the land on which we are gathered is the unceded territory of the Coast Salish peoples. So we've got the Squamish Nation, Musqueam First Nation, and the Tsleil-Waututh Nations. And for those of you who are listening from other parts of the province, we recognize that a similar acknowledgement extends there as well. We would love to thank the Law Foundation of BC. They are the primary funder for the People's Law School, and it's thanks to their support that we can make this sort of production. Peoples would like to extend its gratitude for having this opportunity to present a webinar of this nature. I would like to extend my personal thanks to the team at the People's Law School, Patricia Byrne, the executive director, who has been 200% in support of this project to make it happen. We've got Drew Jackson, senior legal content developer, who has been working behind the scenes on this project and a couple of other projects. He is currently manning the Q&A if you are writing in. And David Condestin, who is also on the People's team. He is behind the scenes as well, doing the chat function. So it's my face that you see on the screen, but it takes a team of people to make something like this happen. And last but not least, and our guest of honor today, Sarah Forte. And Sarah Forte is, she is an employment lawyer. She has been practicing in this field since 2004. She is the founder of Forte Law Employment Law Solutions in Surrey, British Columbia. She started that practice a few years ago, and her team has grown from just her to, I think it's 5 lawyers now. Sarah is, she's incredible. You know, we are so grateful that she's taken time out of her busy practice. This is clearly a very busy time for Sarah. She has a very active blog. She has been on the webinar circuit this week. You won't believe it, but this is her 4th webinar this week. So we are delighted to have her. And I will just add that Sarah is also the mother of 3 school-aged children. So on top of all of this, she's teaching her kids algebra and I don't even know what else. So without further ado, I'd just like to say welcome, Sarah. So great to have you here. Oh, and I think we are.
There we go. I think I'm unmuted.
Super.
Can you hear me now?
So
Can you hear me
welcome,
now?
Sarah. So great to have you here.
Thank you. I am so excited to be here. I'm not sure that I am worthy of that amazing introduction. And I, for the record, have not been teaching any algebra, and sure as heck hope I don't need to, because that would be scary days indeed. But I am really happy to be here. I have done 4 webinars this week after I don't think ever doing a webinar before in my career. So it's been a steep learning curve, but I've learned a lot. And I'm particularly excited today because the webinar is focused on workers' rights. And although there's been a lot of information offerings, I haven't seen too many focused on workers as opposed to businesses. And I'm really happy to be here and providing information, and happy to be here with you, Paula, and People's Law School. So thank you.
Thank you, Sarah. We are so excited to have you. And you know, before we get into some of the more substantive questions, how are things on the ground for you over at Forte Law?
Things are good. It's been, you know, I say good probably because it's Friday afternoon and I'm nearing the end. I did purposely suggest this time because I thought after this I could probably log off for a bit. But, you know, in honesty, it's really challenging. It's definitely a time when many people are calling us in crisis, business owners, workers, and we're doing our best to help them get strategies in place to manage this time that is just completely unforeseen. But, you know, every day we're learning more. There's more information. There's more government programs. There's more available. So I think the hope is there. And, you know, the one thing that I keep reminding myself is that this will end. And so we are in this really challenging time, but it is not going to be forever. And so just trying to look at the issues with the light at the end of the tunnel.
That's excellent, Sarah. And I think the work that you're doing right now is so important. You're helping so many people through what is really an incredibly challenging time. So we'll turn to our first question, and that is, you know, my workplace told me that they have no work for me. Can they lay me off?
So That is a great question, Paula. And, these are questions that Paula and I worked on together to identify the sort of most frequently asked questions over the last couple of weeks. And so one thing I like to start with on this is a frequently asked question because so many people are experiencing layoffs and so many companies are rolling off layoffs for the very first time. So the number one thing I think to say is if you're in this situation, you are definitely not alone. Over 1 million Canadians were out of work as of last week, and I'm sure that number has grown. So we'll give you some information here that can help you out. And like a typical lawyer, I like to not answer the question you gave me, but answer my own questions that are related to that question. And the first one is so this question to me sounds like someone who has not yet been laid off. They're saying, I've been told there's no work, can they lay me off? So putting myself in the shoes of someone who is not yet been laid off, I think there's a lot of uncertainty and worry about what can I do? Like, is there something I can be doing now to be ready or to avoid a potential layoff? And I do have a few tips on that. One is look at your insurable hours. So this is something that's part of the employment insurance, EI, which we used to call unemployment insurance, UI. Maybe that's dating me, but the EI scheme, that EI is not new. It's been in place for a very long time. And its primary purpose is to provide income for people who have lost their jobs through no fault of their own. So, for instance, in a layoff. In the Vancouver region, and now it was helpful to see where everyone's from, so you definitely want to look on the Service Canada website to find your own region. But in the Vancouver region, you need 700 insurable hours in the last 52 weeks to qualify for benefits if you're laid off due to shortage of work. So the number one thing I would do if I was worried about getting laid off was check in with my insurable hours and look at the last 52 weeks and see, do I have that 700 hours? And you might be, for instance, at 690 hours and very close. If you're in a very close proximity and you have almost 700 hours, what I would suggest you do is talk to your employer about that if you think layoffs are coming down the pipes. I find most of the businesses I'm advising really, really want their employees to be eligible for EI, and they want to do whatever they can within reason to help them get access. And one thing your company might be able to do is give you a few more hours. It might be, not even a full day of work you need to make it to the 700 hours. So that's number one thing to do if you're worried about layoffs, is check your insurable hours. Number two thing to do is make yourself indispensable. Think about what it is your company's going through. Come up with ideas. I mean, this is a time of great innovation, and we're seeing a lot of companies completely pivot and change their business models and come up with new ideas. And oftentimes the workers are actually the best people to come up with those ideas because they're the ones interacting with the customers every day or seeing how the internal process works. So don't be afraid to come up with ideas and be part of the solution that keeps you working. So that would be number two, is make yourself indispensable. And then number three is think about your broad skill set. So you might be performing one job, for instance, let's say you're in shipping and receiving. But you might actually know that you can do other jobs within the company. And perhaps the shipping and receiving has slowed down, but another aspect is still going. For instance, if you had bookkeeping skills, your employer might not know that. And so think about transferable skills and making sure that your employer is aware of the full variety of services that you could offer to continue working. So not quite that question you asked, Paula, but that's my number one answer that I wanted to give to this is I think there's a lot of people, and I'm certainly getting calls from friends who are like, I'm worried I'm going to be laid off. What can I do? And so those are the three things. Look at your insurable hours, check, make yourself indispensable, think creatively, and make sure that your boss is aware of all of your skills in case there's other things you can do. And the bottom line is, unfortunately, a lot of people are going to be laid off. So, those are ideas, but they're certainly not a guarantee that you're not going to be laid off. That in most cases, the question being, can they lay me off? The answer is yes. Typically, they can lay you off. There are a few exceptions to that, though, that I wanted to bring up that we're starting to see happening out in the business world. And one of those is if the layoffs are not blanket, so it's not like a shutdown where they're laying off everyone, they're sort of picking certain people and eliminating jobs sort of in one at a time or in small groups. So if you have been selected for a layoff, important to look at human rights round, or you were about to return from a maternity leave and you've been laid off, or you have a disability and you've been laid off, or all of the older people have been laid off. It's those kinds of things are not okay, and employers can't choose who they're going to lay off for human rights reasons. And the other point is if you've made a safety complaint. So let's say, for instance, that you have where you're working, the workplace is not compliant with government recommendations. And Paula and I, instead of being across the city in different living rooms or basements, we are made to sit in chairs that are directly side by side to each other without any protective equipment. So let's say Paula and I had to do that, and then Paula complained and said, "Hey, People's Law School, this isn't safe. What you've set up here." And they say, "Oh, guess what? We had to do layoffs, and Paula, I guess you'll be first." So that could be seen as a discriminatory action, which is not allowed under WorkSafe BC rules. So if you're being chosen for a layoff because you made a safety complaint, that again is a situation where layoffs are not okay. And the third I would outline, and I know we're going to cover this a bit later, so I'm not going to get into too much detail, is if you need to access a protected leave. So the BC government has issued a series of new protected leaves relating to COVID. And so if you have told them you need to take a protected leave, for instance, to care for your school-age children, and they say, okay, well then we'll just lay you off, then again, there might be an issue there. So those are some of my main comments under this question, Paula. I feel like I've rattled on for a long time here. I guess the last point I'll make, and before I see if Paula needs any clarification, is that temporary layoffs can only be 13 weeks long. So if we're talking about can they lay you off, if it's going to be temporary, right now, our law says it can only be 13 weeks. That might change in future. We've seen a lot of change in law so far, but so far it hasn't. And so that would be the longest temporary layoff could be. Paula, looks like you're muted there still. There you go.
Sorry, I was just trying to unmute myself. So Sarah, to summarize then, you're suggesting that if it looks like an employer is going, there's a risk that you're going to lose your job. Number one is to think about the things that you can do to make yourself indispensable. If a layoff is a layoff, so if you are going to be laid off, that is within the discretion of your employer. But there are some situations where that's not okay. And those are the ones you highlighted, like the targeted layoffs, discrimination, if you've made a safety complaint. And if it is a temporary layoff, it's a 13 weeks under the Employment Standards Act. That's correct?
Well summarized.
Thank you. I confess I have the benefit of your notes. So let's move on to the next question. Thank you so much, Sarah. The next question being, in the event that somebody is laid off, do they get severance pay?
So this is another super common question that we're getting. And so the answer to this is it depends. So this is your typical employer answer or typical lawyer answer, but I'm going to explain that. So if the layoff, let's separate out permanent and temporary. I think that's the first division that makes sense. So if your layoff is permanent, so this is not, we don't have work right now, but we're going to have you back. This is temporary. They're saying, you know what, we are unfortunately going to have to let you go, and there's nothing temporary about it. So this is happening right now. Certainly in the industries that have been hardest hit, we're seeing employers going right to this. So would you get severance pay if you're permanently laid off? If you have, so generally you should get some, but there's a few exceptions. One is if you've worked less than 3 months, you may not get any severance pay. It's possible that you aren't entitled to any. Under the Employment Standards Act, you need to have at least 3 months of work to be entitled to notice of termination, which is telling you your job's over at a date in the future, or severance pay. It's also called termination pay if you're let go right away without any notice. So that's one exception to severance pay in a permanent layoff. The other is if the employment has become impossible to perform, and if it's become impossible to perform due to unforeseen circumstances. So there's a section in the Employment Standards Act, if anyone's inclined to look it up, it's section 65(1)(d). And what that section says is if something happens, an unforeseen circumstance or an unforeseen event, and it makes the employment impossible to continue, that employers do not have to give any notice of termination or termination pay. So there have been, if you're an employment lawyer on Twitter right now, which I am, there have been lots of really detailed Twitter debates going on about what this means in the time of coronavirus. In my view, and we haven't had any guidance from the government on this, if it will probably apply in some cases, but it will not apply to all cases. Coronavirus may be an unforeseen circumstance, and that doesn't seem like a stretch to me. But whether your contract is impossible to perform is a really high standard. And so so I'm looking at two scenarios here of layoffs. Okay, so one is you're in an industry where you've been ordered to close, and so your entire business is closed by order of the government. Is that contract impossible to continue? It may be. Whereas if you're in a business where they're just starting to see some slowdowns, they're anticipating, and a few months out, we're going to start to not have enough work, and so they're kind of staging layoffs over time and choosing who's going to go and when, I'm not sure that would meet the standard of impossible. We won't know, unfortunately, until we start to get some decisions from the Employment Standards Branch on this, and that will take probably several months. So those are the two main circumstances, I would say, where you do not get any notice or severance pay, is if your contracts become impossible to perform or you've worked less than 3 months. If the layoff is temporary, so now we've talked about permanent layoffs, which are the same as termination, same as getting fired. All those words mean the same thing legally. But if we're talking about a temporary layoff, then there's another analysis that applies. So in most cases, in a temporary layoff, the employee has to agree to be temporarily laid off. So what our Employment Standards Act says is if you have a temporary layoff, it is a termination, same as getting fired. You have all the same rights unless the employee agrees to it. There's two other exceptions. One is if the layoffs are very common in your industry. So let's say in some industries, it's common not to have full-time work year-round, and there'll be periods of time where people are laid off. Though in those cases, an employer might be allowed to lay off even if the employee doesn't agree. The other circumstance is if it's in the employee's contract. So if the employee and employer have a written contract that says we can temporarily lay you off from time to time, then that's another exception. But unless you fall into those two, which is pretty, like, not many contracts have this in it, and not many industries have sort of that routine temporary layoffs, then the employee has to agree to the temporary layoff. That's a weird thing to say, right? Like, who's going to agree to be temporarily laid off? Nobody is. Like, you can't say, well, you have to keep me at work if there's no work to be done. So, but in effect, what not agreeing to a temporary layoff is saying, no, you fired me and I want my severance pay. So those are sort of a couple of the different nuances around when severance pay is owed. I want to talk a bit about how much it would be, but Paula, do you have any questions about that piece first before I move on? I see you're muted there, so I'm going to assume I've been perfectly clear. You can give me a thumbs up. Severance pay, how much? So this is also a really hot question, right? Like, it's one thing to say, should you get severance pay or not? But I mean, how much might you get is a really critical piece. So how much you get for severance pay comes from three places. The most straightforward is the Employment Standards Act. And again, when Paula started this session, for those of you that have tuned in later, what she said is this is relevant to non-union workers who are in provincially regulated industries, and are covered by the Employment Standards Act. So under the Employment Standards Act, notice of termination, so advance notice of your end date, or termination pay, if you're just told the same day on your last day, is between 0 and 8 weeks. And the only thing that depends on is how long you've been there. So it's by year of service, and it's roughly 1 week per year of service, up to a maximum of 8 weeks. So that's severance category number one. Number two, you look at your contract of employment, if you have one. And if that contract of employment is valid, and you have one, and it addresses termination, that might say what you get for severance pay. If you don't have a contract, or the contract's invalid, or it doesn't address severance pay, then you look at the common law. And what common law is judges over time have made decision after decision after decision and decided on a formula for figuring out what people should get above the Employment Standards Act. And it's based on the worker's age, their length of service, the nature of their job, and availability of alternative employment. It can be as much as a month per year, and sometimes even more, depending on the circumstances. So severance pay can be a lot. Certainly if you've worked somewhere a long time and you're in a job that's difficult to replace, and particularly if you're older, with a recognition that it's typically harder to find another job. There is an exception to this as well, and this goes back to similar to this section 65(1)(d) of the Employment Standards Act, and that's if the contract has become impossible to perform. So that analysis can also apply for common law severance, and it's called frustration of contract, which is a legal term that essentially means between the employer and the employee, something has happened, that means they can no longer work together to complete the contract, which is worker works and employer pays for that work. So that's another thing to think about. Again, if you're deciding, so one thing, you know, I'm talking to a lot of people about right now is, should you agree to a temporary layoff, or should you say no and try to get some severance pay? And I think the main factors that I would be considering if I was looking at that decision are, do you think that the company is going to have an argument that your contract has been impossible to perform? So are they in one of these industries that has been completely shut down, and the Employment Standards Act and judges might say, you know what, under these extreme circumstances for this company, you don't have to pay any severance pay because the contract has been frustrated. So that would be factor number one I would be thinking of. Factor number two would be, do you want a job to come back to at the end of this? Because as I started off my comments with, this will end. We will all get through this and be out the other side. And if you love your job and you love the company and you want to be back and working and you have confidence that they're going to reopen, then you might choose to take a temporary layoff. Because if you say, no, I want my severance pay, the company would have absolutely no obligation to return you to work, and possibly would not want to, because you had chosen to take the severance pay. And on the flip side of that, why might I say, you know what, I'm not agreeing to the termination pay. I'm not agreeing to the temporary layoff. I want my severance pay. And I think what I would be thinking of is this company going to survive? You know, am I going to have a better chance to get severance pay now than maybe I would be down the road? Is there realistically going to be a job here for me? And also, perhaps if you were thinking about leaving anyways, right? Maybe you have another job in mind. Maybe you always wanted to work in a grocery store, they're hiring, in which case you might want to bring your employment to an end and try to get some severance pay rather than agreeing to the temporary layoff. So that's kind of the end of my very long answer to a very short question, Paula. Did I cover everything that you think people need to know about this?
Sarah, I just double checking, you can hear me, right?
I absolutely can.
Super. Sarah, I think that's it's such an interesting answer to the question. It goes to show that there's a lot of there are a number of layers to be taken into account, and particularly that analysis at the end. Do you agree to a temporary layoff, or do you force the termination and try to capture some severance? A question came up for me, Sarah, that is not on our predetermined questions, but let's say you do accept the termination. Would you then be entitled to any benefits outside of your employment contract? Would that trigger, for example, benefits like employment insurance benefits, for example?
So if you are laid off and you get severance pay, then if you otherwise would have been eligible for EI, you would still be eligible for EI. It would just kick in at the end of your severance pay. So for instance, if you got 8 weeks of severance pay, then after that had run out, then you would be eligible for EI, because you've still lost your job through shortage of work, as different from quitting. So that's a really important nuance, because if you quit, and we're going to talk about this later, if you quit, then you typically do not get EI. And so that's an important thing to think about. Just to kind of twist on your question, because you were asking about benefits, so that got my mind thinking about something else. A lot of employers, and not all, but many are continuing people's group benefits while they're on temporary layoff. That is not something an employer is required to do, so they can end your benefits, while you're on layoff, but some are agreeing to continue your benefits coverage as sort of a good faith gesture and to maintain the connection. So again, if you're weighing between, do I accept this temporary layoff, or do I just say no, I'd like my severance pay. Another thing to think about is if they're offering any continuity of benefits, that if you said I want to be severed, you would be giving that up. Got Paula, I can tell you're muted there, so I'll try to fill in the gap. That is, I feel like I've said.
I'm back. Sorry, Sarah. I'm. Thank you so much.
No worries.
We're going to move to the next question. We've got about 10 minutes left for a scheduled webinar. If we go a few minutes over, assuming everyone can sort of stick around a little longer, but let's move on to the next question. Okay. And this is one that I think is coming up quite a bit for people in this era. So maybe you still have a job, but you are not comfortable being around other people right now. Are you required to continue to keep going to work?
So this is another great question. One, I guess I'll just start with a plug for WorkSafe BC. They have this week issued a couple of different policy and guidelines documents. They're on their website. They're in very simple wording. They're easy to understand and follow. So if you have questions about workplace safety, that would absolutely be the first place I would recommend looking. And they have published some things that are specific to COVID. So definitely take a look there. So to me, this question is a bit ambiguous, and I'm sure it was purposely ambiguous, right? So if we read it on its face, this is not someone who is saying, my company is not complying with government recommendations, or I have children at home, or I've been directed to self-isolate because I've just returned from another country. This is someone who's just saying, I just don't feel comfortable being around other people. And in that case, I would proceed very carefully as an employee. You have a right to refuse unsafe work, but if you are refusing just because you're uncomfortable being around other people, that could be the same as you quitting. You could be quitting your job by doing that. So be very careful. A few options that you can explore, one is to think about, are there safety precautions that would make you feel more comfortable? And they may be over and above the government recommendations or different from the government recommendations. And I'll just give one example that I'm seeing at my office building now, which I'm visiting once a week on the weekend usually, is I see a lot of offices have put boxes by still working in the office don't have to have any kind of close contact with the mail or courier. So that to me is one very good way to address it, is think about, is there something that would make me feel comfortable, and raise that with your employer. And it may be like the cardboard box by the door has zero cost. I mean, everybody's got boxes lying around already. So it may be something that is an easy fix and actually maybe helps others in the workplace feel more comfortable too. The other question is that I would be looking at is, can I work remotely? Paula's working remotely, I'm working remotely. Many people are working remotely now that never did before. And so I would be thinking about, is my job something I can do from home? And it may be that you need to explain how and why you can do your job from home to your employer, because they're not probably as familiar with your job as you are. So think about that. Government has recommended that if people can work from home, they should. And so I think this would be a very good time to suggest and try out a work from home option. Another potential solution is, can you volunteer to be laid off? I have seen this happen for some of my employer clients where they've had a work slow down and they're full of angst and worry for their workers and trying to figure out who should be laid off. And if people come forward to say, hey, I'm actually happy to be laid off, and I would be more comfortable being at home and receiving EI than I would be coming to work. So if you need to lay people off, please think about me. And that might be incredibly well received. Again, very carefully not quitting. So not saying, I'm not coming to work anymore because I'm not comfortable, but hey, if I see the work slowing down, if you guys are thinking about layoffs, just know that I would be happy to be the one to go. And it could keep some of your fellow coworkers who are comfortable being at work at work. The bottom line, though, is if your employer is following the recommendations and guidelines and you need to be there in person to work, so you don't have the kind of job you can do remotely, if you refuse just simply because you're not comfortable around other people, you could be quitting your job. And if you quit your job, what that means is you get no severance pay, no termination pay, your job is over, you likely get no EI as well, and you also would not be eligible for the CERB, which is the new program that's come out to sort of cover some of the gaps that EI doesn't have. So I would be very cautious about this, and if it's something that you're thinking about doing, check on WorkSafe, and potentially consult with a lawyer, because the losses that would come from this could be huge.
And thank you so much, Sarah. That is such an important point and something that is really, really worth highlighting. As you were speaking, Sarah, there's a bit of a common thread that I'm noticing in some of the answers that you're providing, which is we're really all in this together. And some of the suggestions that you've come up with in terms of, in the first question, if you think there may be a shortage of work, to think of creative solutions, being more on the front lines potentially than your employer, thinking of ways that you can sort of adapt your job to be able to continue to work, in this example, trying to think of creative ways to make your workplace feel safer to you, maybe above and beyond what the government guidelines are. I think what I'm hearing is really that this is a time to really think outside the box as a worker, as an employee, to kind of craft your own solutions, because we're in such unprecedented times. Every little bit of ingenuity really helps. So,
well, I like your think outside the box pun, given I was talking about the box by the door for the mail. So in some cases, thinking outside the box might be putting stuff in a box. So I agree. I think everyone, there's so much unknown, and business owners and HR people don't have all the answers either. Even the government and lawyers don't have all the answers. So it's a bit of an equalizer, I think, in terms of looking to different people for solutions and suggestions and innovation. It can be an opportunity. So let's get to our last question, because I want to make sure we cover this one. It's a good one.
Yeah, and we've got
for all of us working parents.
Well, exactly. And so this last question, got school-age kids, school's out for summer early. I need to take care of them. My boss is giving me a hard time. Can I be fired?
Right. So this is one area where there have been some recent changes to the law in BC that are really helpful for employees. And those are the new protected leaves under the Employment Standards Act. I won't go through those in detail because there is really good information on the Ministry of Labor website about the protected leaves. But I'll just review generally what they cover. So they cover if you've been diagnosed with COVID, if you are in quarantine or self-isolation acting in accordance with the order of the health officer or under the Quarantine Act, if your employer has told you not to work due to concern about exposure, or if you need to provide care to your minor child who is for a reason related to COVID, which includes school closure. So this hits this bang on. And the last leave covers if you're outside of BC and you can't get home due to travel or border restrictions. So these are all now considered protected leaves in BC, which means if you need to be away from work for one of these reasons, your job is protected. They are unpaid, so that's a critical point. Your company doesn't need to keep paying you while you're at home homeschooling, but they can't fire you for that. This is where this comes in together with the CERB, which I'm calling the CURB. I don't know if it has a shortened name yet, but that's what I'm calling it. So the CURB there's still details coming out on this. Applications, I understand, will open on April 6th, but it does cover as one of its eligibility groups people who have stopped working because of COVID, including to care for children. So answer to this question is, can you be fired? No. And if you need to be away from work, you should look at the CURB program, the CERB, and see if you are eligible. There's more details and eligibility criteria, but one of the large groups it's expected to cover is folks who have to be home with their kids now. I've talked right till 4:46, so I'm sorry for the. I'm hopeful I've covered most of the points that people had. I did see. I can see a bit of the chat. I was trying not to get too distracted by it, but I think a number of the questions that were being asked have been answered. But if you can, it looks like someone's muted Paula. I guess we know who their favorite is. So if we can,
I think
yeah.
I'm now unmuted. Is
Okay.
that the case? Fabulous,
Yeah,
Sarah.
we can hear you.
Sarah, thank you so much. You have done an outstanding job of answering all these questions. I think we are receiving, I can see from the Q&A that we are receiving a number of questions, but we won't have time to answer any additional questions today. We will be gathering the questions and providing responses to the most common questions on the People's website starting next week. Just like to highlight a couple of resources. Sarah and her team at Forte Law have got an incredible number of resources on their website. I encourage you to check out their blog. If you have questions, you're seeking legal advice, her team's information is here on the slide, info@fortelaw.ca, or you can call. Sarah, it's been so great having you here. Thank you so much. I think the information you provided is so valuable, so thank you. From People's perspective, we've also been very active. This has been a big week for People's. We have launched a couple of other information products. We've got a web page that deals with COVID-related questions, and so there's some questions on there, or some Q&A about work-related questions about other aspects like you can't make your rent, what do you do, or consumer scams that are related. So I encourage you to check out that page on our website. It's actually had a record number of visits. Another thing that we've done this week, which was scheduled prior to any of this, was we've launched our chatbot on Facebook, and it's called the Beagle, and you should be able to see an image of the Beagle. It's on the right-hand side of your screen, and it's able to fetch the answer to your everyday legal problems. And so there is a COVID or coronavirus related some options there for you, as well as consumer questions and some other topics that are covered. So I encourage everybody to check out all these resources. They're fantastic. And we would like to extend a very warm thank you to all of you who have joined us here today. It really is wonderful to have you here. We're so glad to have you online, and thank you for that. When you go to leave this meeting, you'll be prompted. There's a screenshot at the bottom. You'll be invited to participate in a survey. We would love it if you would complete that survey. The information that we produce on our website, the content is driven by public demand and need. And so your guidance is particularly important in that respect. We would love to hear from you in terms of what you'd like to receive in terms of future webinars. This is our debut, and we hope to have more to come. And so if you have a moment, we would ask that you please fill out that survey. And one final thank you to you. Thank you so much for coming and joining us here today. And I should add, for joining us on such short notice as well. This really was a fast-tracked webinar. So thank you.
It's my pleasure. And thank you, Paula and People's Law School, for having me. I hope I just saw some lovely notes coming up on the chat. So I really do appreciate that feedback. I hope that we were able to give some information to help. I know for me, my focus this week has been how can I help? And I'm hoping to help by providing some good information that people can rely on.
Absolutely, Sarah. I think you've done an incredible job, and you are certainly helpful. And thank you for all the hard work that you're doing. And this is number 4 for you. So I hope you have a restful weekend. Everybody who has tuned in, we wish you well. We wish you excellent health. And we really we hope everybody's doing well. And we're, like you said, Sarah, we all will get through this. So thank you, everybody, and stay well.